Get a drink of water here. Next thing is discussion and possible action related to an appeal on the Sussex County Planning and Zoning Commission's decision to deny subdivision application number S-2021-23, Stillwater Harbor subdivision. Appeal of standard subdivision plan denial for Stillwater Harbor LLC. In the matter of the Stillwater appeal, I move that the council affirm the Planning and Zoning Commission's decision to deny the preliminary subdivision plan filed by Stillwater Harbor LLC for the Stillwater Harbor subdivision. I will provide reasons which are based on the standard of review read by our attorney, Mr. Moore, at the start of the hearing, which are incorporated here in this reference. This is in summary only, which will not include citations or more expansive reasoning. Those can be found in comprehensive written findings given to the clerk of the council with this motion to publish in the record and incorporated by reference. And I'm going to give those in a minute. Mr. Moore, you want to read your thing? Yes. No, about how what we do and don't do when we do this.
That standard of review I
yes.
read at the beginning of the hearing.
Okay.
That's what was just.
We haven't got to read it again, have we?
No, we don't need those now.
Thank you.
And we have the.
I've got enough. Thank you.
Okay. I'm sorry. So
that's all right.
It is the actual motion that needs to be introduced to the clerk at this point.
Correct. Madam Clerk, here are the written findings for introduction to the record, which are incorporated by reference and deemed part of this motion. There are 8 pages there. I'm not going to read all 8 pages, which is good for me. I'm going to read a synopsis of 4 pages. The Commission provided its decision within a required 45-day period. In its September 29, 2023 appeal letter, appellant alleges that the preliminary subdivision plan should be automatically approved when the Commission did not act on the plan within 45 days. Despite appellant's contention, the 45-day clock does not start to run until the record has been closed. To do otherwise would require the Commission to render a decision without the ability to review the complete record, which includes all relevant facts, supporting documents, comments from various agencies, staff, and legal counsel. The record for this application was not closed until June 8, 2023, when Chairman Wheatley stated, quote, "We will now officially close the record for Stillwater Harbor." On June 22, 2023, the Commission voted unanimously to deny the plan. This vote took place 14 days after the record was closed and was well within the 45-day period. The Commission engaged in an orderly and logical review of the evidence, which involved the proper interpretation and application of the law. The Commission provided comprehensive reasons for its unanimous denial of the plan. In fact, the Commission's motion covered 19 pages of transcript and contained 12 reasons, 3 of which contained between 6 and 8 subsections with additional points. This is one of the longest motions the Commission has presented. It clearly demonstrates the Commission's decision was a result of an orderly and logical review of the evidence, that there was substantial evidence in the record to support its decision, and that it engaged in the proper interpretation and application of the chapter. Appellant relies upon a Delaware Supreme Court decision which held that, quote, "When people who own land zoned for specific use are entitled to rely on the fact that they can implement that use, provided the project complies with the subdivision ordinances subject to reasonable conditions imposed by the Planning Commission to minimize impact." This is the proper standard. However, the plan simply does not comply with Sussex County Code 99-17B, and the appellant did not effectively address the mandatory considerations for all subdivision applications in Sussex County Code 99-9C. The plan does not comply with Sussex County Code 99-17B. First, Sussex County Code 99-17B mandates that the access to the subdivision shall be from a public highway having a width of at least 50 feet. The record includes testimony from the appellant's engineer that the width of the right-of-way varies from 42 to 46 feet. The appellant's failure to provide code-compliant subdivision access left the Commission no choice but to deny the plan. The plan does not comply with Sussex County Code 99-9C. Second, Sussex County Code 99-9C sets forth 17 mandatory factors the Commission must consider in its decision whether to approve or deny a subdivision application plan. As mentioned before, the Planning and Zoning Commission considered all these factors and outlined the plan's deficiencies in detail in its motion. The imposition of conditions will not rectify ongoing flooding. Third, imposing conditions based on appellant's wide-ranging deficiencies under Section 99C and 9970B will not bring the plan into compliance. For instance, the frequent flooding of River Road was emphasized in hearing testimony and an opposition letter from the Indian River Volunteer Fire Company. DENREC also raised the flooding and drainage issues, stating, residential properties and roads also flood regularly because of local runoff, because of stormwater, drainage, and transportation infrastructure that is undersized or in disrepair, and that drainage deficiencies include undersized or non-existent stormwater drains, stormwater systems that require maintenance, and low ground surface elevations. These deficiencies result in problems such as localized flooding, backwater flooding from inland marsh, or coastal inundation directly in the river bay. DENREC and the Secretary of the Delaware Department of Agriculture also expressed concern that removal of forest lands will likely result in increased drainage issues and flooding risk to current and future residents. The Commission found that the appellant did not seek alternative designs to mitigate the known drainage and flooding risk from the proposed forest removal, despite the concerns expressed by DENREC and the Secretary. The excessive flooding will also have a direct impact on transporting children to and from Stillwater Harbor. Currently, when River Road is flooded, local school children are frequently picked up and dropped off at the fire hall rather than their home due to road closure. Based on hearing testimony, the Commission found that this is a safety concern that currently exists, and it should not be made worse by approving more development with more school children who cannot be picked up upon and dropped off at their regular location because of frequent weather events. Jackson Drain Lane does not benefit the Stillwater Harbor lots and is inadequate to solve an emergency access concern. Fourth, while the appellate attempts to rectify the flooding issue through use of Jackson Drain Lane for emergency access, Jackson Drain Lane is a 12-foot wide unimproved road, which is a private easement benefiting a limited number of properties. Stillwater Harbor's 123 lots are not among those properties benefiting from the easement. In an attempt to gloss over this issue, appellate relies on 16 Delaware C 6701A for the premise that a fire company is authorized to trespass on property in response to a fire or other emergency. The Commission cannot condone the unauthorized use and make land use decisions for the general public welfare based on foreseeable trespasses over property that is still not part of Stillwater Harbor. That would be overreaching and could result in Jackson Drain Lane becoming a regularly used means of ingress and egress for Stillwater Harbor lot owners, which for a multitude of reasons it is clearly not suitable. In conclusion, the foregoing facts demonstrate multiple deficiencies in the plan presented to the Commission. These facts were collectively confirmed by statements in the record at the public hearing, and there is substantial evidence in the record to deny the plan based solely on the appellant's inability to comply with Sussex County Code 99-17B, let alone 99-9C. The Commission's findings include detailed, thorough, and well thought out reasons for its unanimous vote to deny the plan. Of utmost importance is the failure to provide code-compliant subdivision access over a public highway that is at least 50 feet in width as mandated by the Sussex County Code. This deficiency is only exacerbated by the road's habitual flooding, which is common and well known in the area, and was acknowledged by the Indian River Volunteer Fire Company, DELDOT, DENREC, and the appellate's own engineer testimony at the public hearing, as well as that of local residents. For the reasons above, which were considered a part of this motion, together with the entire written findings which have been already introduced into the record, I hereby move that the Council affirm the Planning and Zoning Commission's decision to deny the plan.
Second.
Have a motion and a second.
I will point out before voting, and you mentioned it twice in your reading, that includes the written formal opinion and findings that you've introduced to the clerk of council.
Correct. That's all part of the record. Those 8 documents, those 8 pages, there's 4 pages.
Yes.
Have a motion and a second. Any question on the motion? We'll take the vote. Mr. Hudson.
I agree with you, Mr. Vincent, and I agree with the Commission's decision to deny subdivision Stillwater.
Mr. Schaefer.
Mr. President, I believe the Commission acted and engaged in an orderly and logical review of the evidence and acted in an orderly and logical fashion. And based on the reasons given by you, I agree.
Mrs. Green.
I agree with the Commission. It was thorough, well written out, well explained, your testimony here today, and I vote that it stands.
Mr. Riley.
I also vote and agree that Planning and Zoning acted in a logical and orderly fashion, and we should uphold their decision. So I agree.
Well, certainly after all I read, I do agree with Planning and Zoning's decision. And
Mr. President, before you strike the gavel on it, too, there were two things. If they would votes be yes or no, both Mr. Riley and Mr. Schaefer said, I agree, and it should be clear for the record that you're in favor of the motion, as Mr. Vincent said, and there was no testimony today. It was based upon the testimony previously given, Mr. Green.
we will back up to Mr. Hudson.
I agree with the previous testimony and with Planning and Zoning Commission's decision to deny the subdivision,
You vote yes.
and I vote yes.
Mr. Schaefer.
I agree, based on my statement I made a minute ago, and I vote yes.
Mrs. Green. I'll let you
I
make
vote yes.
Okay. Mr. Riley.
I vote yes.
I also agree with Planning and Zoning. I agree with their decision to deny, and I will vote yes on the motion. Motion carried.